Richard, thank you so much for joining us tonight. It's a real honour to have you with us and to hear from you. And so I'd like to hand over to you now and just share your experience and some pointers that will help us in our prayer later on. Thanks so much, Richard.
Thank you, Andrew, and thank you very much, everyone, for having me to speak to you tonight about an issue that really is, I think, one of the most far-reaching and important issues that we are currently facing as a nation. And I really sincerely mean that, more over and above even the COVID-19 crisis that we are fighting at the moment. This is one of the most important, far-reaching decisions that we are going to have to make as a nation in our referendum, which is whether or not to pass this law. Now, if I could look at the very first, or perhaps the second slide of this presentation, which is that this is not a referendum on the rights or wrongs of euthanasia. What we are considering here as a nation is not whether we think that euthanasia is a good thing or a bad thing. It's a question of whether a particular law, which is this law, the End of Life Choice Act 2019, should be passed into law in this country. It's a very different thing. I know that there will be people listening tonight who may conceptually be in favour of euthanasia. That's fine. I'm not here to challenge your own position on euthanasia. What I'm here to challenge you to consider is, how do you wrap a law around it? And does a law for euthanasia, allowing it, does it actually work? And is it safe? That's really the fundamental question. The question that we are being asked as voters is this law safe? Should we pass it into law? Now, we could look perhaps at the third slide. I'm the spokesperson for a group of around about 200 lawyers across the country. We comprise a number of our country's finest Queen's Counsel and academics and senior lawyers from a variety of legal disciplines, criminal law, family law, etc. And we are here to tell New Zealanders, and tonight to tell you, that this law that you are considering whether or not to vote for is the most dangerous and risky and flawed piece of legislation that we have ever seen as a group of lawyers. That is how concerned we are with this particular law. And we've looked at it for quite a long time now, and we've noticed that it hasn't improved. In fact, as it's gone through Parliament, it seems to have almost got worse. I know that they have now restricted it to terminal illness, but there are still a multitude of problems and flaws with this particular law. So what I'd like to explore tonight is, why do we think that this law is dangerous? Why do we think that it is just far too risky? And why do we ask you to vote no in this referendum? I'd like to look at three different reasons tonight. They're not the only reasons. There are, in fact, a multitude of reasons that we have as to why we think this law is far too risky. But I'm going to give you three tonight. The first, if we turn to the next slide, is this notion of choice. Because, of course, this is what the proponents of this law have been trumpeting for some years now, that the idea is that New Zealanders will be given this choice through the Act. And we want to challenge that. What we say is that actually that's false. The idea of choice is false. And the reason for that is because choice in New Zealand is actually an empty and vacuous term. Choice is not a level playing field in this country, and it never has been. In our country, the powerful and the privileged get choice. The poor, the weak, the defenceless, and the vulnerable, they don't get true choice. For them, their choices are much more limited and, in fact, in some cases, are non-existent. And this is the important thing to bear in mind about choice. What the New Zealand public is being asked to vote for here is something that the New Zealand government and our healthcare system cannot possibly deliver equitably across the country. And I ask you to stop for a moment and consider the state of play of our healthcare system and our society at the moment. We have serious inequities in the delivery of palliative care services across our country. We know for a fact that some parts of the country, especially up far north and down parts of the South Island, cannot access proper palliative or good quality palliative care services. Second, we have a Māori claim currently before the Waitangi Tribunal claiming that the healthcare system is sick and racist towards Māori. Third, we have a lot of terminally ill Kiwis who are currently being denied Pharmac funding for medication that could keep them alive for many, many years. Fourth, we have a society that is experiencing widespread loneliness and isolation and marginalisation, especially amongst our elderly. We know from statistics that 1 in 5 elderly New Zealanders suffer from extreme loneliness. That is a very, very sad indictment on our society, but that is a fact. And the next problem with the current state of play is that we've got rampant elder abuse in this country. We know that 1 in 10 New Zealanders at the moment are victims of elder abuse. Now, that's around about 70 to 80,000 New Zealanders are victims of elder abuse. And finally, we know that there is increasing institutional abuse against the elderly. In the rest homes, we see almost every month or every few months, there's another rest home that's come into the news because of the way that it's neglected the people in its care. Now, into all of this, we are now seriously considering as a society throwing this end-of-life choice bomb. And it's going to apply to everybody in this country who's terminally ill. That means it's going to apply to privileged Kiwis. They'll get their choice. But the question I have is this: it will also apply to the poor, the weak, and the vulnerable, and the neglected, and all of the people that I've just mentioned. And what we have to ask ourselves is, will they also truly get a choice? You see, what New Zealanders have been asked to vote for here is a system that is going to be telling these poor people that I've just mentioned, who are terminally ill and who are being failed by our healthcare system and our society, it's going to be telling them, look, we can't care for you, but we can help you to end your life if you want to. After all, it's your life, your choice. What choice are these people truly going to have? That is the fundamental challenge that I put to you. Now, this is what is happening overseas. The vulnerable under these types of institutions, under these types of regimes, the vulnerable are the ones who really cop it. In Canada last year, we know from this first annual report on medical assistance in dying in Canada, this is their first report, we know that last year, 13.7% of those Canadians who chose euthanasia said that one of the main reasons they wanted it was because they were lonely and isolated. Now that's 13.7%. That's about 770 people last year. Was their choice a true choice? Now 34% of those who chose euthanasia last year in Canada said that one of their main reasons was because they felt that they were a burden on their family, their friends, or their caregivers. Did they make a true choice? We know also from Canada that in May 2018, the Canadian Quebec College of Practitioners wrote to the health minister in Canada and said, we have a serious shortage of palliative care in Quebec. And the result of that is that many thousands of terminally ill Quebec citizens are going to be pressured into choosing euthanasia because they can't access proper palliative care. Where was their choice? In Oregon last year, according to their statistics and their annual reports, last year in Oregon, where they have an assisted suicide regime, over 50% of those terminally ill people in that state said that one of the main reasons they requested assisted suicide was because they were afraid of being a burden on their family. Over 50%. How is that a choice? And this is what I put to you. There is no compassion or choice and the assisted suicide of a person who just doesn't want to be a bother. That's hardly the kind of society that we want to have or to live in. We also know from Oregon that between 63 to 67% of all assisted suicides in the last 5 years were of people who are on low incomes who were accessing state insurance there. So what the experience with euthanasia actually shows us, is that for vulnerable people, like the ones that I've mentioned, there is actually little or no choice. And that this so-called right to die, for some, very quickly becomes a duty to die for others. Let's look at the next slide now. This is the second key reason why we oppose this act. And that is that this act will not protect vulnerable New Zealanders from being manipulated or pressured into requesting euthanasia. Now, that's no surprise to us because that's been the experience overseas. Let's look overseas at a number of the countries that have legalized euthanasia, and let's have a look at how the weak and the vulnerable are actually the ones that have been targeted. Because we've seen abuse of the most vulnerable citizens in so many of the jurisdictions that have legalized euthanasia. I mean, for example, in the Netherlands, just 2 years ago in the Netherlands, where they are euthanizing children, where they are euthanizing newborn babies with severe disabilities, where they're euthanizing dementia patients and psychiatric patients and depressed people, where they're euthanizing 7,000 people a year. There was a Dutch woman, elderly Dutch woman with dementia, who refused to be euthanized and who was then drugged and forcibly held down by her family members while a doctor administered a lethal dose. That is a fact, and we'll give you the link so that you can see that actual report. That is what happened. Across the border in Belgium, where they're also euthanizing children and psychiatric patients, the Euthanasia Review Committee, they call it, has recently been exposed as corrupt. Now, this is a committee that oversees and is supposed to review the euthanasia regime. We have the exact same committee proposed in this law. The review committee there was exposed by one of its own members as being corrupt. The member said that this committee in Belgium is breaking the law, it is approving wrongful deaths, and that they are ensuring that doctors who commit abuses get away with it and get total impunity. What about Canada? Canada's only had a euthanasia law for 4 years, so you would think surely no problems there. Well, let's have a look. Here's the case of Roger Foley. Roger Foley was a seriously ill Canadian man pressured by hospital doctors into requesting euthanasia because they didn't want to give him the care that he really needed. What about this woman, Candice Lewis, in her mid-20s, suffering from spina bifida and serious chronic illnesses, again, pressured by her doctors at the hospital into requesting euthanasia. They targeted her mother. This case, Sean Taggart. Sean Taggart was a poor Canadian man, suffered from ALS. The Canadian healthcare system refused to pay for the care that he really needed and instead offered to pay for his euthanasia. In the end, he was forced to take it. What about this article here? In May 2018, I mentioned this before, the Quebec College of Practitioners told the health minister that this lack of palliative care services in Quebec was forcing some people in Quebec who were terminally ill and couldn't get palliative care to instead request euthanasia. Then we have this 2019 report by the United Nations Special Rapporteur on Disabilities, expressing serious concerns about the impact which Canada's euthanasia law was having on disabled people in Canada, and about claims, many claims that this rapporteur had been receiving that disabled people had been pressured to seek euthanasia by their doctors. Now, in response to these abuses in Canada, what has the Canadian government done? Well, it's expanding the law. That's been the response of the Canadian government. According to the Canadian government, everything is going so swimmingly in Canada that they've now decided to expand the law to non-terminally ill Canadians and disabled Canadians. So that is the state of play in Canada. Against that background, so let's have a look at the End of Life Choice Act and ask ourselves, does this protect vulnerable New Zealanders? And I want to put to you that the claimed safeguards and protections in this Act for supposedly detecting whether a person might be pressured into requesting euthanasia are woefully inadequate, because this law puts the entire burden of detecting and ultimately deciding whether a person in New Zealand is being pressured into requesting euthanasia onto a single doctor. Only one doctor under this Act is required to detect whether the person is being pressured. And that doctor may not even know the patient, may have only met them a few times. And then it tells that doctor, this law tells the doctor, that all they have to do is do their best. Yes, you heard it. That's the colloquial Kiwi term that's been put into this legislation. Just do your best, mate. Those are the exact words that a doctor has to do to determine whether a person who is vulnerable is actually being pressured. And in doing their best, the doctor is only allowed to talk to those family members of the patient that the patient allows them to talk to. Now, our own doctors, the Royal College of General Practitioners, told the Parliamentary Select Committee that with that test, they were not going to be able to detect whether vulnerable people were being pressured. It was impossible. And that as a result, there were going to be wrongful deaths under this law. There you have it. So that's straight from the horse's mouth, because doctors are the ones who are going to be on the front line of this process. And we have to ask ourselves then, how many wrongful deaths are we prepared to tolerate before we say this is unacceptable? You know, we abolished capital punishment in this country just 3 decades ago because we could not stand the prospect that one innocent person might die through capital punishment. And here we are now seriously proposing a law where many, many more innocent people could die, and there are pathetically inadequate tests to detect whether they might be pressured. How many wrongful deaths are we prepared to tolerate? Now, the next slide, and this is the third and final point that I want to make about why we think this Act is so dangerous, is that if this law passes, it's not going to be the end of the conversation. It will only be the beginning. Some people call this a slippery slope. We call it a logical progression. The editor of the Australian newspaper, Mr. Paul Kelly, in 2016, he phrased it this way, and I've put this in the slide. He said that experience in other jurisdictions leads to the unambiguous conclusion that the threshold event is the original legalising of euthanasia. And after this, there's only really one debate, and that's over when and how to expand the sanctioned killings. Because he argues, well, if you're going to give euthanasia for end-of-life pain relief, then how can you deny it to people who are in pain but who are not dying? And if you give the right to adults, how can you deny it to children? And if you give the right to people who are in physical pain, how can you deny it to people who are in mental pain? And if you give this right to people in mental pain, how can you deny it to people who are just tired of living? And this is the problem. Logically, if we legalise euthanasia just for terminal illness, as we are now being asked to do, we are actually going to cross the Rubicon. Because what's going to happen is that this is now going to create a legal entitlement. And what happens when you give just a few people this legal entitlement and you deny it to others? Well, in Canada, there's multiple litigations in courts right now for that very reason, by people who are not terminally ill, who are saying that law, the terminal illness law in Canada, discriminates against me. And in New Zealand, I can assure you, in a situation where only some people can avail themselves of this new right and others can't, inevitably we are going to see our courts and the court of public opinion, I think, inundated with cases that will argue that this is discriminatory. And the pressure will go back on our parliament to expand the law beyond terminal illness to non-terminal illnesses, to disabilities, to chronic illnesses, to mental illnesses, and yes, even to children. And that's no surprise, because in other countries, that's exactly what's happened. Now, Mr. Seymour, who proposed this and brought this law to us, David Seymour, he says, no country who's ever enacted a euthanasia law has ever gone back. Well, that's because with a euthanasia law, there is no going back. There's only one direction to go. The only logical trajectory of a euthanasia law is expansion. And in every country that we've seen where euthanasia has been legalized and been in place for at least 4 years, we've seen expansion, either legislative expansion or interpretative expansion. By that I mean legislative, where they've changed the law to expand it; interpretative, where I mean doctors who are on the ground have been very, very loose in the way that they interpret the law. In Canada, as we've seen, in just 4 short years, the government's already saying, let's expand it. Because it's not fair, because why should we only give it to terminally ill Canadians when there are all these other non-terminally ill Canadians who are also suffering, and they should have it as well. In the Netherlands, we've seen in particular interpretative expansions. We've seen also the law expand to disabled newborn infants. We've seen since 2010, we've seen more and more euthanasia deaths of people with dementia, and we've seen an increase in the number of euthanasia deaths of people with mental illness. And just last month, the Dutch parliamentarian Pia Dijkstra submitted a new bill to allow anybody over the age of 75 in the Netherlands who felt that they were at the end of their life and they wanted to die, that they could just get euthanasia. Across the border in Belgium, we've seen legislative expansion that has expanded the law to children, no age limit. And in the South American country of Colombia, they've just expanded their law just in 2018 to also extend to children. So it is, I assure you, a logical and a practical or empirical certainty that if we cross this Rubicon and allow terminal illness to be the determinant of euthanasia, if we allow euthanasia for people with terminal illness, I guarantee that within 5, 10, 15 years, it will be available also, it will be expanded to many other types of New Zealanders in situations that we feel less and less comfortable with, because that is exactly the track record in those countries overseas. And so we really have to ask ourselves, as a country, how do we want to look in 5, 10, 15, 20 years' time if we vote for this act? That really is the question. What do we want to become as a people and as a nation? Thank you for your time. You've all heard, no doubt, the old maxim that evil flourishes when good people do nothing. Well, you're all good people, and I just ask that you please don't do nothing. Don't be silent, because as Martin Luther King once said, our lives begin to end the day that we become silent about the things that matter. This law greatly matters to you, to me, to your parents, to your families, to our communities and to our nation. And I ask that you please join with me in opposing it and spreading the word about its dangers. I thank you for your time, and I ask you for your prayers for those of us who are standing up against the proposed law. Thank you.